So welcome everyone to this regional session on Europe at the conference 70 Years Protecting People Forced to Flee, organized on the occasion of the 70th anniversary of the United Nations High Commissioner for Refugees. My name is Roberto Cortinovis. I'm a researcher at the Center for European Policy Studies in Brussels. And I will be the moderator of this session, which is organized in partnership with the ASILE Horizon 2020 project. As a first thing, let me remind you that simultaneous language interpretation is available for this session. You can select your language of choice clicking on the interpretation feature in the Zoom toolbar. The title of this session is Unpacking EU Asylum Policy in Light of the UN Global Compact on Refugees, the Impacts of Containment on Trust and Refugee Protection. Over the previous year, 2020, EU policy developments on asylum have been heavily influenced by mounting evidence of systematic and often violent rejections of asylum seekers at EU borders, so-called pushbacks. In parallel, the outbreak of the COVID-19 pandemic has led to the introduction of border control and travel restrictions, which have made it increasingly difficult for people in need of protection to seek asylum in Europe. Against this backdrop, the European Commission presented its new pact on migration and asylum last September. The new pact promises a normalization of EU policies by replacing ad hoc emergency measures with a durable framework that is able to work both in normal times and in times of crisis. The pact legislative proposals aim to establish a new system of internal solidarity within the EU, which gives member states the possibility to contribute in a number of ways, including as a new element by providing assistance to each other in carrying out procedures for returning irregular migrants. The pact puts a strong emphasis on an expanded use of accelerated asylum procedures at the border, based on the assumption that a relevant share of asylum seekers arriving in the EU come from countries with a low recognition rates or that can be considered as safe. As will be reflected in today's discussion, cooperation and partnership with third countries lies at the core of the new pact. What we can see here is the continuation of previous EU policies and initiatives driven by containment, that is, by the objective of limiting onward movements of asylum seekers from regions of origins towards Europe. These measures coexist in the pact, not always easily, with the promise for increased refugee mobility through expanded resettlement and complementary pathways for admission. In these sessions, we are going to look at this and other developments in Europe through the lens of the Global Compact on Refugees, both its guiding principles grounded in international refugee law and its overall objectives to enhance solidarity with refugee and host communities. We are also going to consider to what extent current EU policies address the call in the Compact to better include refugee voices and agency in the design of relevant initiatives. We have a panel of experts, which includes distinguished academics, but also activists and experts with relevant experience in devising initiatives to support refugee rights within our societies. I'm going to present our speakers briefly. Due to time constraints, I cannot provide detailed descriptions of their profile. So we will first have three core presentations. Our first speakers will be Rosemary Byrne, Professor of Legal Studies at the New York University of Abu Dhabi in the United Arab Emirates. We will then hear from Jens Vedsted-Hansen, Professor of Law at Aarhus University in Denmark. Our third speakers will then be Audrey Macklin, Professor and Rebecca Cook Chair in Human Rights Law at the University of Toronto in Canada. After our speakers' interventions, which will last for around 10 minutes each, I will give the floor to our discussants for their comments and observations. As you can see on the agenda, we are very glad to have with us today four discussants. Meltem İneli Ciğer, Assistant Professor at the Suleyman Demirel University in Turkey. Mohammed Badran, Founder and Director of the Association Syrian Volunteers in the Netherlands. We will then hear from Anila Noor, who is a member of the European Commission Expert Group on the Views of Migrants and also, among others, Managing Director of the organization New Women Connectors. And finally, our last discussant will be Nikolas who is a researcher specializing in international refugee law at the Danish Institute for Human Rights. As our discussants are supposed to speak for around 5 minutes each, we will then have time for an interactive discussion with the audience. And in view of this, I would like to invite you to type your question using the Q&A tool that is available in the Zoom toolbar. And when you please type your question, please also specify to whom of our panelists you would like to address your question. So as you see, we have a very rich panel with 7 interventions. And this also implies that we need to be quite careful with timekeeping. So without any further ado, I would like to turn now to our first speaker, Professor Rosemary Byrne from the New York University in Abu Dhabi. So Rosemary, I think a good way to start our discussion today is to focus on the issue of solidarity and fair sharing of responsibility. Solidarity is at the core of the Global Compact, but is also a key legal principle of the Common European Asylum System. So I would like to ask you, what is your view on how solidarity is framed in the new Pact on Migration, in how it's embedded in recent EU initiatives, and in particular when it comes to the external dimension of asylum? And also based on this, how do you assess current developments in new cooperation with third countries? Rosemary, I give you the floor.
Thank you very much. I am really pleased to be part of this discussion and to be speaking about solidarity, because it's not only at the core of the proposal for a new migration and asylum pact, but critically, solidarity has been deployed in the context of refugee protection for the 7 decades of which UNHCR has been in the refugee protection business. And I think it's important, the work of Madeline Garlick at UNHCR on solidarity has been one of the seminal pieces of writing. But it's really important to acknowledge how central it is in the global protection lexicon and also in the Global Compact for Refugees. It's a principle that highlights that the Global Compact represents political will and ambition of the international community as a whole for strengthened cooperation and solidarity with refugees and affected host communities. And I think what's important in thinking about the way in which the Global Compact embraces solidarity is the distinction they're making between strengthened cooperation and solidarity. They're overlapping, but they're distinct. The same as solidarity, indeed, is applying to refugees and to host states. And again, a sort of dual objective that is very important, one not at the expense, indeed, of the other. And the other factor that I think is really interesting, particularly now about the elaboration of solidarity that the Commission has undertaken, as controversial as it may rightfully be in many regards, is that solidarity as a concept itself in the context of COVID has really been resuscitated by the international community. The Secretary General's calling for solidarity, the UN High Commissioners, both for human rights and refugees, Security Council, General Assembly. In ways for past pandemics, solidarity was really, being replaced by the more mechanical, technocratic call for international cooperation. And I think the reason that solidarity is so important in the context of migration is because of the spirit and political will that really is about redistribution, sacrifice perhaps for the common good. And so in a way, it's really interesting to see how with the Commission's sort of introduction of what almost seems to become an oxymoron of compulsory but flexible solidarity, it's coercing virtue. We have this kind of model of solidarity that's emerging. And I also kind of, in the context of thinking about this in an international gathering and having sat through a wonderful panel this morning on Africa, one does have to say, well, why is Europe so important in these discussions? And I think there are a number of reasons, and I think in part it's the nature of immigration and refugee law more generally. That if you look at the way in which particularly restrictive laws and immigration and asylum are replicated, it's almost like it has a contagion. And it's not just Europe. If you look at Latin America, there have been studies that have shown how when countries introduce certain measures, they tend to be repeated in other jurisdictions. So simply that kind of normative transfer is important. But if you confront, and I really admire Roberto's incredibly concise summary of the new pact, because I mean, you have even there 500 pages. You've got over 40 pieces of legislation dealing with an asylum regime. So in Europe, you really have the most developed regional system that has teased out many of these concepts, which is why it provides a focal point and why its approach to solidarity is so important. And I think why its emphasis in one regard on containment has really caused consternation. For others, it may seem that actually the approach being taken by the Commission that offers flexibility may indeed be, as some are saying, a concession to the Visegrad states, who in the last wave of an asylum crisis from 2015 were deeply resistant to their obligations for relocation, that by adding a kind of a la carte approach to solidarity, where states can select whether they're going to relocate refugees, whether they're going to provide operational support or whether they're going to facilitate and support returns, is in a way kind of diluting the spirit of solidarity. It's kind of a technocratic solution, a realist solution. But what I really wonder is, in the broader context of international law, not only in the narrower domain of refugee protection, will this approach have a significant effect within asylum and outside? So I think that, you know, what's happening in Europe within our now 27 states, the discussions that we're having mirror discussions in other places, but are also important. Also, if you look at the focus on third countries, you know, what is the impact of this pact on countries, you know, that were once corridors, referred to often as transit countries or third countries, and now have the real danger of becoming the buffer state. And if you go back, as those of you who are older in the audience will remember, during the accession process in the last big enlargement, 2004, that was a real concern of the candidate countries who were building up their capacities for refugee protection, when the Commission and member states were really quite clear that part of that objective was to allow for a buffer, a protection from migration into the old member states. So when you're looking at the kind of approach to solidarity now, which is really based on containment and continues the approach, it's certainly not introducing or inventing it, it has really, I think, significant ramifications for those countries bordering the EU. And what OECD data is showing is that also, while we tend to look at, and the first thing you learn when you are introduced to refugee law, is the reality that most of the world's refugees, the overwhelming number, remain in the global south and often in countries next door to them. But what is beginning to be evident in trends of migration is that actually migrants are settling farther away than their countries of origin, that they're traveling farther. So therefore, the situation of third countries and transit countries becomes more significant, both in terms of the concerns of residents within them, but also in terms of a broader policy that's being put forward. And I think the last sort of issue about research that is telling us a bit about what the future might be is recent work on what might happen with travel in the post-COVID era. And all of us are envisioning a future where we'll be having these really odd virtual engagements. And yet at the same time, what researchers are also seeing is that there's likely, once travel opens up, for there to be a blip in travel, for there to be a resurgence in individuals migrating, et cetera. So I think, you know, the future is really pointing to the significance of this pact and the significance of this pact on neighboring jurisdictions. I want to just say, because time is very tight and we have really wonderful speakers on the panel. So I want to just say a few words about the experience that's unfolding in the humanitarian disaster in the Lipa camp in Bosnia. Not only because it's deeply disturbing, as all humanitarian crises are in different ways, but because I think it really epitomizes the kinds of scenarios that EU migration policy can, if not facilitate, is unable to respond effectively to. The one kind of issue that has come up in this, where you have literally hundreds of individuals who are in the winter, we're living in a camp that was designed as a response to COVID for the summer. And the camp, because the conditions were so appalling, it was set on fire in protest. And now you have hundreds of people literally living outside in the snow in degrading and indeed dangerous conditions. But when you look at the kind of interaction between the regional and international actors, you're reminded of how complex the scenarios are within domestic jurisdictions. That while you have the Lipa camp, you have not far a facility that was built with the money, European Union money, a reception facility that local authorities are refusing to use. You have this standoff between the local authorities and the national authorities, the regional and the international. You have a complex dynamic between the governance within Bosnia and Herzegovina. And you have resentment and fear among local population in terms of what the ramifications are. And it really comes down to when we were looking at during the accession process, the Baltic states had this metaphor of their fear of becoming a closed sack. And while the European Union was really dangling the prospect of membership in return for capacity building and strengthening the rule of law in the candidate countries, that kind of leverage is not really available or viable in the range of states that the European Union is interacting with. So Bosnia is a potential candidate country. It's not doing great on its scorecard because of the many obstacles domestically that it's dealing with. But the idea of imposing migration management as one of these obligations may not be as enthusiastically taken up as we saw during the kind of major enlargement process that was underway in the 2000s. So I think it really raises a lot of concerns and issues. And so what I'm going to do now is turn the floor over to Jens Vedsted-Hansen and Roberto, because I believe that he'll be speaking in a very similar vein on related issues. So thank you very much for your time.
Many thanks indeed, Rosemary, for your very rich presentations, for introducing so well the concept of solidarity, the implications of how this concept is translated into concrete policies, and also how it's so important for understanding current developments, including this other, if you want to call this, crisis that is unfolding very close to Europe in Bosnia. I think your interventions paves very well the way for our second presenter, Professor Vedsted-Hansen from Aarhus University. With you, Jens, we would like to delve into more details into current policy and legal developments in Europe concerning asylum and refugee in light of the Global Compact. Rosemary has already introduced some aspects of the new pact. To you, I would like to ask, do you think the Commission succeeded in the stated objective of striking a balance between having fast, streamlined procedures in the field of return, asylum, and the need to uphold key protection standards in the asylum process? So Jens, I give you the floor. Thanks.
Thank you very much, Roberto, and thank you to you also, Rosemary, for your excellent introduction to this discussion. as Roberto indicated, I'm going to, sorry for the term here, zoom into the more specific details of the EU Pact on Migration and Asylum. And given the particular occasion of the UNHCR's anniversary, my point of departure will actually be the UN Global Compact on Refugees, adopted in December 2018, which can be seen as a cooperation framework that provides for a background to the examination and assessment of EU asylum policies, including the more recent EU Pact. Let me just briefly summarize some of the main features of the Global Compact. The guiding principles have been described as humanity and international solidarity. The compact is grounded in the international refugee protection regime, meaning the 1951 Convention and the 1967 Protocol, and also further guided by the instruments of human rights, humanitarian law, and other elements of international law. This altogether is meant to provide a basis for predictable and equitable burden and responsibility sharing, which certainly is a relevant criterion for assessing EU policies, both internally and in the external dimension. And finally, the objectives of the Global Compact are described in paragraph 7 as these four: easing pressures on host countries, enhancing refugee self-reliance, expanding access to third country solutions, and supporting conditions in countries of origin for the return in safety and dignity. Now, I'm not going to present a comprehensive conclusion as to the compatibility of the EU Pact with these objectives, but I will try to now highlight some of the most important features that have been brought forward by the Commission in its EU Pact presented in September last year, as well as some of the accompanying legislative proposals. The question, of course, is, do they in some way, in some meaningful way, correspond to the objectives and guiding principles of the Global Compact, to which the EU member states in a coordinated manner actually adhered back in 2018? At least most of the member states did so. I think it is fair to condense the elements of the EU Pact as a policy response in these 7 points. Solidarity and responsibility sharing, which is essentially to be seen in the EU Pact as a quid pro quo between the solidarity measures and border control and screening and containment. The frontline states wanted solidarity for obvious reasons, as we have seen also in a recent statement by Spain, Greece, Italy, and Malta, while the other, at least that's so the Commission hopes, the other member states will accept some elements of solidarity, as Rosemary mentioned, being made contingent, though, on border control at the external borders, including screening and some containment measures. And this is the very delicate balance which has to be struck both in policymaking and in subsequent implementation. And I'm going to highlight some risks in this towards the end of my presentation. The second element in the EU Pact, I would say, is the prevention of secondary movements, which is closely linked to the issue of containment at external borders. Then, thirdly, securing returns, which is actually integrated also into the solidarity mechanism, because so-called return sponsorships, quite a strange phenomenon maybe, is actually presented in the in the EU Pact and the legislation launched as a solidarity measure. So member states can show solidarity by sponsoring return efforts. Also, there is going to be a common EU return system and indeed enhanced cooperation on readmission to countries of origin and transit. The remaining elements of the EU Pact, I would say, are addressing the problem of the vanishing mutual trust within the common European asylum system. I'm coming back to this, but as you all know, the mutual trust is a fundamental precondition for the common European asylum system, while at the same time mutual trust has really been vanishing. And now the Commission is suggesting that mutual trust should be expanded or created, secured through robust governance and implementation monitoring. The monitoring is important, and we might come back to that in the discussion. Lastly, crisis preparedness and crisis responses, external border management, including search and rescue mechanisms, and finally, internal cooperation are also put on the agenda in the EU Pact. And talking about internal cooperation, one term that comes to mind here is the UN Compact is referring to as third country solutions. In one way, the EU Pact is also alluding to or attempting to promote third country solutions, even though it's a kind of two-way road here, as I shall illustrate in the following. If we now consider the potential impacts of the emerging policies and practices under the common European asylum system, as we have seen during the past decade, or even since the enlargement in 2004, to which Rosemary alluded, then it is interesting to see how, as I said before, how mutual trust has been really a kind of overarching parole or program, and at the same time a vanishing reality. And what I consider to be a very serious risk inherent in the EU Pact is that mutual trust internally may not become effectively enhanced, while at the same time the dilution of mutual trust may actually sort of become transferred to some elements in the external dimension by way of the safe country concept, which is really likely to become more exposed and to be given higher priority. The safe country notions are mentioned with quite some emphasis in the EU Pact. And as I have tried to argue in a blog spot on the ASILE forum a couple of months ago, this is to be operationalized in two different dimensions, so to say. There is, however, a significant risk that the safe country notions may become partly a self-fulfilling prophecy. And as I said, there is a risk that the dilution of mutual trust and other protection standards internally in the common European asylum system may impact what you could term the external protection standards and the actual implementation of such standards. Let me try to explain briefly. As regards safe countries of origin, the proposal for an asylum procedures regulation, including the recent amendment to that proposal, will provide a new ground for considering a country a safe country of origin by referring to recognition rates. In itself, as Roberto mentioned, the EU Pact is based on the position that we have an increased tendency towards mixed arrivals or mixed migration flows. And this will then play together with the idea of safe countries of origin, in the sense that if a certain country of origin has a recognition rate for protection seekers below 20%, that should in itself provide a criterion for that country to be considered a safe country of origin. That is a fairly sort of fairly far-reaching delimitation or definition of safe countries of origin. And to make the risk clear here, it should be mentioned that in crisis situations, this percentage criterion will be enhanced or increased up to 75%, which makes it totally absurd that countries from which 3 out of 4 applicants are being recognized as in need of protection should be considered a safe country of origin. Also, the safe third country notion is going to become widened or expanded under the legislative proposals. We already saw how it has been diluted or watered down in the EU-Turkey deal made in 2016. And I think it's safe to say that the proposals are designed to legitimize what was already done in 2016. So it will be a kind of empirical matter to what extent that really lives up to effective protection principles. These safe country notions will become implemented in the context of border procedures. And I think it will be quite crucial to the actual implementation or the actual effects of these safe country notions, in which way the modalities of the border procedure will be working and what consequences the border procedures will have. The idea is to make accelerated procedures become a mandatory arrangement, and some parts of the accelerated procedures will also, under a mandatory mechanism, become implemented in the border procedure. That is in itself a quite risky undertaking, as is well known for those who have, for instance, had a look at the recent European Parliament study on border procedures. Finally, the border procedure has to be seen in connection also with the arrangements for so-called pre-entry screening. There is a proposal for a separate regulation on screening at the external borders. And as far as I can see, there is a quite significant risk that the screening may become conflated with the border asylum procedure, which in turn is supposed to be connected to the border return procedure. In one way, you might argue that border screening already should take place under the Schengen Borders Code. So there have been proposals, suggestions that this pre-entry screening is superfluous. On the other hand, if it's going to have a separate meaning and justify the significant resources that will be spent on this pre-entry screening, it may become a separate border control mechanism that will apparently also allow for unclear criteria for which decisions are being made, for which impact they will have on the next stages. And there is an apparent absence of procedural guarantees in these quasi-decisions to be made in the pre-entry screening. Finally, it is quite obvious that as part of the containment rationale, detention is going to be a systematic element of this screening at the external borders. It has been suggested that this will provide for Moria 2 or whatever name of hotspots you may want to illustrate, to use for illustration of this point. So to sum up, I think there is a quite clear risk that some of the diluting protection standards, some of those tendencies that have undermined mutual trust internally, may spill over as a kind of normative transfer into the external dimension of EU asylum policies. We may come back to further aspects of this, but I would like to stop by now and thank you for your attention.
Many thanks. Yes, Jens, for your intervention and for providing such a detailed comparison of the new pact in light of the Global Compact. You mentioned really a number of aspects that I think lay the ground very well for our discussion. You mentioned in particular the dilution. I quote from your intervention: the dilution of protection principle and mutual trust the vanishing mutual trust between member states, how this trend is impacting and is going to impact on protection standards, also when it comes to relations with third countries. So thanks a lot. I now immediately turn to our third speaker, Professor Audrey Macklin from Toronto University. Canada is indeed often presented as a champion for the implementation of the Global Compact on Refugees, in particular when it comes to resettlement and other pathways for admission. But at the same time, Canada has also come under criticism for its safe country arrangements with the EU, which allow to return asylum seekers to the US without assessing their asylum claim. So to you, Audrey, I would like to ask to draw, if it's possible, to draw a comparison between these two asylum models, Canada and the EU. What are the main differences and similarities? And now the example of Canada can also us to better understand developments in the European Union. Audrey, I give you the floor.
Roberto, thank you very much. And thank you to you, Rosemary and Jens, for wonderful, informative introductions and presentations from which I've already learned a lot. And really, I offer Canadian examples as points of contrast and comparison here. I know there's a separate panel that is explicitly addressing the North American context, and so I'm not going to attempt to provide any kind of comprehensive review. 3 points about Canada as distinct in its situation from EU member states. First, Canada is geographically isolated from those countries that are understood to be refugee producers, so to speak, and indeed isolated from every other country except the US. And that means that virtually all refugee claimants who reach Canada do so by flying in or coming overland from the US border. And one of the results of that is that Canada, frankly, like most other member states party to the Refugee Convention, spent a lot of energy and resources on deflecting and preventing refugee claimants from reaching their territory. But Canada does it with great success, I must say, through remote control techniques that are less visibly violent than the ones that we see in other parts of the world. And they involve pushing the border out and preventing people from getting on planes destined for Canada. And in the case of the Safe Third Country Agreement, which I'll discuss in a moment, preventing them from crossing the border from the United States into Canada. Another important distinction is that Canada does not have or share with other countries a regional or multilateral framework on either human rights or on asylum. So we are obviously not members of a kind of regional community like the European Union. We aren't governed in common by something like the European Convention on Human Rights, or indeed by the various EU policies, laws, and practices that can then be, for example, litigated before the European Court of Justice. Our relationships on asylum and refugees to other countries is bilateral and frankly transactional. And I think this reduces the scope within which to talk about solidarity. We are, of course, active at the international level and understand, Canadian foreign policy understands itself as actively engaged at that global level of solidarity. And finally, I'll just point out that Canada is what I have called a normative country of immigration. Immigration is part of the national narrative. That is, immigration is necessary and vital to the social, demographic, economic construction of Canada in a way that is common to all settler societies, but is different from so-called old world countries that understand immigration as relatively recent, a supplement, and potentially conflicting with conceptions of national identity. With that as an introduction, then let me just move to describing very briefly some of the policies that Canada has with respect to refugees and refugee claimants or asylum seekers that are in some sense analogous or isomorphic with EU policies. Many of them were inspired by EU or European state policies, but there has been, I would say, policy transference back and forth. Let me just start with the Safe Third Country Agreement between Canada and the United States. It looks much like the Dublin regulation, but it is bilateral. It is hard to frame in the language of solidarity because the fact is that it redounds almost entirely to the benefit of Canada if you understand benefit to mean deflecting asylum seekers. By this, I mean that Canada-bound asylum seekers at the US border will be turned back to the United States. US-bound asylum seekers at the Canadian border will be turned back to Canada. But this is hardly a balanced or symmetrical relationship because Canada's geographic isolation means that we receive relatively few asylum seekers who must pass through Canada to get to the United States, whereas it is so difficult to reach Canada other than by passing through the United States or flying in, that the flow is almost always kind of south to north. And so it isn't a kind of solidarity kind of relationship. Its origins lie in Canada, in a sense, exploiting 9/11 and US desires for greater control of the Canada-US border to Canada's advantage. As part of those negotiations, Canada secured this Canada-US Safe Third Country Agreement. It only applies at land borders between Canada and the United States. Doesn't apply to airports, doesn't apply at marine borders. Historically, it has been challenged before Canadian courts as a violation of Canada's own Canadian Charter of Rights and Freedoms. And here you see the distinction between how this agreement would be challenged in Canada versus how, for example, the Dublin regulation has been challenged, starting with the Belgium-Greece case in 2011, right? This is all predicated on Canada's own internal human rights obligations. And the way the litigation worked in its first challenge in 2007, and now again with a successful challenge in 2019, is the idea that because the United States does not honor its own international legal obligations with respect to refugees, both in the risk of refoulement, but also how it treats asylum seekers, Canada violates its domestic human rights obligations under the Charter by deflecting refugee claimants into that system in the United States. And so most recently, that argument succeeded before the federal court, and Canada was found to be violating the Canadian Charter of Rights and Freedoms by deflecting refugee claimants, asylum seekers, into the US system, primarily because of US detention practices. Now, I will say that there were a wide range of violations that the Canadian litigants argued, but the court decided it on the narrowest possible grounds with respect to US practices with detention. And again, I think you can see the resonance with the European court decisions regarding the Dublin regulation. Now, this case is on appeal to the Federal Court of Appeal, and anybody's guess what will happen. But suffice to say that in the interim, Canada has adopted a new law by which anybody who passes through one of 5 countries en route to Canada and makes a refugee claim in one of those 5 countries will have their refugee claim in Canada not refused, they won't be deflected back, but they will be shunted into an inferior process that is considered to be a fast track to no. And what this demonstrates, and I'll just leave it at this, is the ability of the government to try to pivot, to find different ways to refuse, to deflect, to diminish refugee protection in Canada through various techniques. I can return to that if there are more questions. We had in Canada, inspired by the European Union, a safe country of origin model for several years. And indeed, when Jens was describing the ways in which, under the current pact, the EU proposes to define what is a safe country of origin, there are resonances with how the Canadian government defined a safe country as well. But this short version of how it worked really is that it took the Aznar Protocol and plunked it down into Canadian law. And roughly speaking, if you were a citizen of an EU member state and a few other states, then you would be shunted into a very inferior refugee determination process. And the idea there is that all countries in Europe are safe. And to make it even more dramatically similar to the EU, one of the arguments was that if you are unsafe in any particular European member state, mobility provisions under the EU, under the European Union system, allow you to move to another state. So it really was very much a transposition of the logic of the Aznar Protocol. It was, of course, designed really to deflect Roma asylum seekers from Hungary and other Central and Eastern European states. Lastly, I'll just say briefly about the ways in which irregular entry has increased in Canada owing to, frankly, the governance of Donald Trump. And this has created various issues around defining the border, irregular entry, and much as 9/11 gave license to Canada to move forward with the Canada-US Safe Third Country Agreement, it used COVID to start issuing what are called direct backs and are effectively pushbacks into the United States from points along the Canadian-US border where the Safe Third Country Agreement doesn't actually apply. Last, I want to say something about the Global Compact for Refugees and the mention of Canada and its advances in resettlement. I'll just bring up two other points. One with respect to capacity building. Canada, as I understand it, is certainly funding some of the countries in Central America to build capacity in their refugee determination system, one presumes, to reduce the pressure on Canada with respect to asylum seekers from that part of the world. Secondly, with respect to refugee self-reliance, there is this discussion about complementary pathways where refugees who might otherwise qualify as economic immigrants can be processed in that way. But last, with resettlement, I'll say that Canada has earned much praise globally with respect to its resettlement of refugees, most recently and notably Syrian refugees. I want to close by just injecting two cautionary notes into that celebration of Canada. I think refugee resettlement is a fine thing, for sure. But first, the numbers in absolute and relative terms compared to the need are trivial. Secondly, to promote resettlement in countries, for example, in Europe, carries some risks with it. One risk is this: if a country is, and a government and a population is adamant about reducing the admission of refugee claimants, asylum seekers, there is a great danger that resettlement will be presented as an alternative. That is to say, another reason to restrict and exclude asylum seekers is that we can pick and choose the truly deserving, in quotes, refugees through a resettlement process. It's important to note that resettlement, as I'm sure you're all aware, is entirely discretionary, and that siphon can be turned on or off at any time by countries. Secondly, one of the dimensions of Canadian resettlement that has been particularly promoted is so-called private resettlement that allow private citizens to participate in the resettlement process, in effect by providing financial, moral, social, and practical support for resettlement. It's a fine thing as long as it is not a move to privatize resettlement. And if you have a country that doesn't have a tradition of resettlement at all, and you try to introduce private resettlement, first, people may resist for the very valid reason that they see this as an attempt to privatize, which should be a public responsibility. And secondly, you're just not going to get any take-up on it. And I would say in Canada, there has always been a strong push to retain the public commitment to resettlement, and that's got to be vital. And last, as a measure of solidarity, I would make the point that there's an interesting solidarity that can be created between private citizens and refugees, and it's worth exploring what the meaning of that solidarity is and what political valence it has. Thank you very much.
Many thanks, Audrey, for your intervention. I think you outlined very well this comparison between the EU and Canada is very useful, and also some scholars have argued that containment policies, when adopting containment policies, states are using creative legal thinking, and so you outline very well how this also, they are also learning from each other when while introducing some practices that may have the effect of limiting substantially international protection. So thanks a lot. I would like to thank also all the other speakers, 3 speakers, for their intervention. I would like now to turn immediately to our discussants. As I mentioned, we have 4 discussants. I would like to ask them to pick up some of the issues or arguments raised by the speakers, but also feel free to add any additional aspect that you may find relevant. So let's start with our first discussant, Meltem İneli Ciğer from Suleyman Demirel University. Meltem, you have worked extensively on EU-Turkey relations on asylum, and the EU-Turkey statement, the 2016 statement, has been often presented by EU institutions as a model to be followed when cooperating with third country. So what I would like to ask, if you maybe can touch on your intervention about the legacy of this statement on current EU reforms, and of course also how the global compact. What the Global Compact tell us about the impact of this model of cooperation. Meltem, the floor is yours.
Thank you very much, Roberto, and thanks a lot for just invitation to act as a discussant in this really nice panel with such esteemed colleagues. Now, let us start with the Global Compact on refugees. Imagine, or let's assume that we don't know anything about the GCR and we just didn't listen wonderful presentations in this panel. When you Google the Global Compact of Refugees on Google and you find UNHCR's website dedicated to GCR, one sentence welcomes you. The Global Compact represents the political will and ambition of the international community as a whole for strength, cooperation and solidarity with refugees in affected host countries. So when you read the sentence, you will understand that the Compact is about offering better protection to refugees, giving displaced persons safe and humane ways to seek asylum and be admitted to host states. So the Global Compact is about solidarity with refugees, but also states already hosting large number of refugees, especially those in the Global South. On the one hand, we have the Global Compact, and on the other hand, we have the new EU Pact on Migration and Asylum, which was just presented a few months back. And when you read the press release presenting the new Migration Act, you see that fair sharing of responsibility and solidarity is also one of the pillars of the new EU Pact on Migration and Asylum. However, when you read the proposals and policy documents, which is, as Rosemary mentioned, pages and pages, you realize that the pact actually places too much emphasis on return and readmission and efficient and faster asylum and return procedures, as Jens just perfectly described. The pact even proposes, in my understanding, to redefine solidarity as to include return sponsorships, which is basically if a member state cannot effectively return a third country national or a stateless person, it asks another member state for help. And if another member state does this, to return a third country national or a stateless person, this is understood as a means of solidarity in the pact, which I find it quite problematic because it erodes the meaning of solidarity and cooperation, which is a central theme of the Global Compact on Refugees. Solidarity should be about protecting refugees and protecting displaced persons and not returning them. The problematic approach to intra-EU solidarity in the newly presented Pact on Migration and Asylum sadly is also reflected in solidarity with third countries. As you mentioned, the new pact does little to change EU's approach to EU third country cooperation arrangements and deals with third countries. Although the pact is presented as a new beginning, it does not promise to change the utilitarian and pragmatic nature of EU third country cooperation agreements and deals in the field of migration. I'm sure everyone in this virtual room are aware of legal problems relating to the EU-Turkey statement of March 2016. a lot of authors has in-depthly examined the legal problems and the humanitarian problems related to this deal, and we have just wrote about it with Orçun Ulusoy in the ASILE blog. But I'm sure you already know that how the EU did not own up to the EU-Turkey statement, and the statement is accepted as a soft law instrument concluded between member states and Turkey individually, which as a consequence, the EU in a sense escaped legal responsibility arising from the arrangements of the EU-Turkey statement. How the camps like Moria ended up being built to detain hundreds of asylum seekers and migrants on the Greek islands as a consequence of this deal. More importantly, how the statement, which was agreed as a temporary measure to deal with a so-called migration crisis in 2015, is in actually its 5th year now. And readmission of migrants and rejected asylum seekers to third countries became a central theme in European migration policies to manage asylum and migration. So finally, what is quite problematic about the EU-Turkey statement is also how the statement managed to turn resettlement, which is conventionally a purely humanitarian act and tool of responsibility sharing, into a migration management tool. As you know, resettlement from Turkey to EU under the statement is conditioned upon a person to be readmitted by Turkey, which already hosts the largest number of refugees in the world, with more than 4 million forcibly displaced persons. So when you compare the GCR and the new Pact on Migration and Asylum, you see stark differences, and you see stark differences in defining solidarity. In my understanding, if the EU really wants to align its asylum law and policies to that of the GCR, it needs to rethink its understanding of solidarity, its cooperation with third countries, and focus on protecting people, not returning them. And this is my take on a comparison between the GCR and the EU third country deals and the new Pact on Migration and Asylum. Thank you.
Thanks a lot indeed, Meltem, for outlining some of the key challenges raised by the current EU approach, and also for outlining the need for a kind of reshaping EU policies or a change in approach in EU policies if we want to address these key challenges. I would like now to turn to our second discussant, Mohammed Badran, founder and director of the Association Syrian Volunteers in the Netherlands. Mohammed, the Global Compact includes positive language on refugee participation in the process of policy design, and refugee-led organizations are expected indeed to play a key role in this regard. So we are very eager to have your take on this, based on your experience in advocating in international and also national venues to promote the inclusion on refugee voices and experiences in decision-making. What is missing in current EU policies, and how could the current situation be improved?
Thank you, Roberto, and hi everyone. Thank you also for inviting me to be a discussant in this great topic and panel. I think I will start with, trying to see how, when the start of the so-called refugee or migration crisis in Europe in 2015, and how when we look at solidarity and at that time, and then we see and then compare it to now, we see that at that time, especially, everyone remembers the picture of the child Alan when he found at the sea how all most of the EU countries, they took the action immediately in opening the borders and accepting refugees and welcoming refugees, also from the civil society. However, in these 5 years, we haven't seen any changes or improvements in the lives of refugees and migrants. Even worse, actually, the opposite happening. The example of the Camp Moria and the situation that we arrived, but even how solidarity changed from from 2015 to when the situation of Moria happened. Neither of that, like most of the EU countries, they tried to blind their eyes about the situation, and they didn't want to even accept. It was very hard even to accept any kind of refugees or helping these refugees, even though that when we talk about sharing responsibility, that should be the main thing, whether this new pact on migration or the global compact when we talked about it. You mentioned about the work that refugee about refugee-led organizations and the work that they have been doing in the last few years. I think that they have done a tremendous job in advocating for a meaningful participation of refugees in all of the policy making processes and development. And that is essential. I mean, meaningful participation is essential. I mean, how can we make sure that any deal or any policy that it's directed to help refugees, as we intended to see these policies, is being developed without the perspective of the refugees and of the most affected ones. If we look at the new pact deal, we see that there are some language that has been reflected. I mean, in the GCR, there are more than 4 paragraphs mentioning the meaningful refugee participation of refugee-led organizations and how important is that, and that is the result of the work my colleagues that we have done in the last few years. But also, if we see in the new pact, we see that some of these languages are being reflected. For example, the expert group that they have put into action, that's something great. But I mean, to move to even further, I mean, how can we, even in the third country, if we are going to make a deal with Turkey or another country, how are we going to make sure that the refugees who are we making the deal for them are being represented and their interests are being protected, rather than just being the political interest of any countries just reserved? But how can we make sure that the refugees who are the most affected
Yes, I think we have a problem.
Who needs to be centered at the middle. Hello, can you hear me?
Yes, now yes. Please continue. We lost you for a.
Yeah, I mean, to end with my my take on, I think meaningful refugee participation is essential, and it should be at any pact or any new policy that we are going to achieve that the improvement of the lives of refugees on the ground. And it's the first step that's actually needed to achieve the self-reliance of these refugees, as well as a better cooperation between the different stakeholders. If we don't take that seriously, if we don't take refugee voices, if we don't see them as an active agents, then we cannot have any. We're gonna just have like the vicious cycle of these policies that just keep repeating itself and without any improvements, and we are just gonna have to face the worst, even worse than what happened with the camp of Moria, and that's what I'm afraid of. Yeah, I will stop here. Thank you.
Thanks, Mohammed, for your very interesting presentation, and also for really outlining the crucial importance of including refugee experiences and voices on new policies, and how this is indeed crucial for improving on the ground these policies and avoiding some of the negative consequences that we have seen in the previous years, and also remembering how the global compact of refugees indeed set the ground for for this additional effort. I would like to turn now immediately to our third discussant, Anila Noor. You have a long-standing experience, Anila, too, in the field of advocacy and developing initiatives in support of refugee women. But you are also a member of the European Commission expert group on the views of migrants in the field of asylum, migration, and integration. So I would like to ask you to give your assessment of the current challenges in Europe based on our discussion so far. Anila, I give you the floor.
Yes, thank you, Robert, and thank you everyone for having me here. It's a really privilege to be part of this discussion, but as a refugee myself, it should be our right to be part of this discussion and to be on the table of discussion, which is becoming more complicated. So our speakers in this session and our panelists, they already talking about the new pact of migration asylum, which is proposing fair share responsibility and solidarity between member states. And if we see the new pact, they are really trying to propose new entry points, which including screening involving health, identity, and security checks. And they also trying to make new arrangement of faster asylum border process involving decision within 12 weeks and such as faster returns of denied application. But I really want to highlight the compact, which is objective number 4, or sport condition in countries of a region for returns in safety and dignity, which is taking as a element in the new pact about promoting voluntary return is a key strategy objective of the EU migration policy in the new pact. Because why I'm trying to take this specifically element from the EU pact, because as a representative of refugee and migrants, we believe every policy, they are just taking their own understanding how they need to deal with these communities. But we as a refugee, we think they are way behind understanding our needs and how they are presenting us. Though this new strategy, which they are taking as a voluntary returns to make us safe returns for the people who really want to go back. But we as a refugees representative, we think this is a weaponizing. They are making a tool, making us a lame excuse to force communities to return back to their countries. Like if in case of Afghanistan, in so many countries, they're taking as a safe country to return, but actually it's not true. How they're presenting Afghanistan is safe. It's a big loss for if we are sending back people to Afghanistan from different European countries. And on the other side, we also thinking about voluntarily, how they are making this assessment, how you can make sure what is voluntarily, because the system is not recognizing the need of refugees, asylum seeker, and they said, okay, they are coming by illegal pathways and they are entering Europe illegally. So instead of giving them safety, instead of giving the right to asylum, instead of giving them to stay safe, they are forcing them to go return back. So we are in conversation and we are trying to be a part of EU advisory board and part of expert group. We are trying to actually negotiate and give them the understanding, direct what we are consulting from our communities and give them more understanding that this is a long way. Still, this new pact is becoming like a quite ambitious, but so much is vague, is so many gray areas, and we are trying to negotiate how we give them understanding about what refugees need and what need to be changed. And this is no way to send them back to their countries until there's a giving a proper trainings, proper channels, either it's social, psychological, and even the data, how their interpretation of safety is really needed, is interpretation of voluntarily needed. And we are trying to give them the tools and the understanding. And about the mention about human element is being missing. And we really need to put who these refugees are we talking about. They're women, they're unaccompanied minors, they are undocumented people, they are stateless persons. We really need to unpack these all elements. if we are talking about in the policy, these policy languages are getting more and more complex, and we really need to change it. And we really need to change the narratives, how they are putting, again, like if they are talking about solidarity, but still, if you go in deep in the policy, they are really taking it as a burden. They are not sharing their share, but they are thinking migrants, refugees who are coming into the Europe, they are burden, and we need to share this burden. So this is my intake, and I'm here really to see how we can put this, unpack this meaningful way to complement this policy when it comes to implementation. Thank you.
Many thanks indeed, Anila, also for focusing your intervention on the objective of ensuring returning safety and dignity. And we know that some previous speakers have already mentioned the pact put a strong emphasis on return, but what are the conditions for ensuring sustainability of return of people from Europe? So it's now time for our last discussant, Nikolas Vedsted from the Danish Institute of Human Rights. So Nikolas, you are the last discussant. You also have the privilege in a way to wrap up our discussion. You worked recently on a comprehensive study with Professor Vedsted-Hansen on EU arrangements with third countries in the area of asylum in the context of the ASILE project. One of the key issues you have looked at is the interplay in this arrangement between containment and mobility approaches, one of the issues that has been touched also by previous speakers. So based on that study, what are the main features of these arrangements, and what are the key issues that they raise?
Thanks so much, Roberto. It's lovely to be with you. And as you mentioned, my brief today is to briefly give you a sort of readout of this forthcoming publication, which examines EU arrangements with third countries, primarily of transit, that would be Turkey, Serbia, Niger, and Tunisia, in the field of asylum governance. So in my 5 minutes, I'm going to touch on three sort of key takeaways or headlines, and then point to some further research needs in this area. The first is I would like to discuss very briefly the role of the Global Compact on refugees in these third country arrangements undertaken by the EU. And the takeaway here essentially is that EU arrangements do not reflect a significant engagement with the GCR itself at this point. Now, of course, it's important to bear in mind that the GCR is a relatively new instrument. And of course, the COVID-19 pandemic has certainly disrupted the rollout and implementation of the compact. That said, when we look at EU publications in this area, when we look at primary EU instruments like the EU Trust Fund for Africa or the Madad Fund, we don't see strong references to the GCR. And perhaps most tellingly, in the EU Pact itself, the GCR is only mentioned with respect to third country solutions to admission in the EU. And most notably, of course, the policy transfer, as Audrey mentioned, of Canada's private sponsorship of refugees model. So in sum, while current EU arrangements with third countries clearly do overlap with GCR objectives, more substantial alignment with the compact from the EU side remains to be seen. Secondly, if we could characterize some of these third country arrangements undertaken by the EU since 2015, there are two sort of standout characterizations to be made. The first is that rather than conducting legal agreements in this area of asylum governments, the EU has focused on a clear informalization trend, taking arrangements beyond the limits of EU law into the policy or informal realm. And this, of course, raises questions, as Meltem has mentioned, with respect to the EU-Turkey statement, and questions of transparency and accountability within the EU legal order. Simultaneously, while these EU instruments are generally informal in nature, the actors that implement them are increasingly varied. So while EU agencies such as EASO and Frontex are physically present in a number of these third country arrangements, notably in Serbia. The EU financial instruments I mentioned earlier include a very broad range of both international organizations such as IOM and UNHCR, as well as international and national NGOs as implementing partners. So what then can be said about the nature of these EU arrangements with these four predominantly transit countries I've mentioned? As Roberto mentioned, there is a very strong focus on containment in EU policymaking in this area. And while mobility, that is third country solutions via resettlement and complementary pathways, are present in some EU arrangements, they remain relatively small in scale and often ad hoc in nature. And moreover, we see this quite interesting dynamic emerging whereby these mobility structures are embedded in broader containment approaches. So Meltem's referred to the use of resettlement as a migration management technique in the context of the EU-Turkey statement. And also if we look at the emergency transit mechanism being operated out of Niger as a corollary to EU policy in Libya. So as a result, while containment remains the dominant paradigm in EU arrangements, we can see the emergence of this contained mobility dynamic in current instruments. And of course, this rather containment-heavy nature of current EU arrangements makes access to international protection in these third states particularly crucial, with onward mobility options often extremely rare. And there are real questions as to whether current EU arrangements do allow access to international protection in these third states. If we think about Turkey and Serbia, for example, there are real questions, as Jens has raised, about the notion of safety under the safe third country notions. In Niger, there's questions about uptake and quality of a national protection system. And in Tunisia, there is the complete lack of a national asylum system. So finally, I'd like to raise a further area for legal research in EU asylum governance policymaking. And that is, of course, well, what are the legal limits of these containment arrangements? And it's worth recalling here that while the GCR is a non-binding instrument, it's explicitly grounded in hard international law, in particular the 1951 Convention and its 1967 Protocol. In turn, then, these international instruments are, of course, anchored in the various EU treaties, the TFEU, for example, and of course, the EU Charter. So there's further work to be done to unpack the applicability of international refugee law, human rights law, and EU law standards in the external dimension of EU arrangements. Thank you very much.
Thanks a lot to Nikolas for your intervention and for really outlining a number of issues of research that of this field of arrangements with third countries, raise legal issues and the impact on third countries. We are having some issues with time constraints, and this implies that we have only a few minutes left. So we will need to revise a bit our schedule, and I would like to address immediately some of the question from the audience. And there is in particular one question that I think it's particularly relevant from Reshad Yalali from ECRA, and I think it's also relevant for many of the discussants, because many of the discussants that I've outlined the features of this containment approach in light of the Global Compact on Refugee. This has emerged very well in our discussion, but the question is how this path-dependent, let's say, approach towards containment can be broken. The question specifically is, my question is how we as civil society organization, we can push the UN member state to respect and stick to the Global Compact on Refugee objective, and how can it be litigated given the non-legally binding nature of the Global Compact on Refugee? So legal litigation has been mentioned. I would like to ask our speaker if they think this could be a way to to change, to produce change in new policies, or what are the other tools, means available to address some of the most negative aspects of the current trends towards containment. I would maybe like to give the floor to our three speakers, Rosemary, Jens, and Audrey. I would like really to ask you to be brief because we have only a few minutes left. I give the floor to Rosemary if she wants to comment on this.
Very briefly, I'll defer to Jens as the EU lawyer, but I think a lot of what is coming across in the presentations is that actually the direct and indirect effect of containment policies result in human rights violations, so that while one can't litigate the global compact, one can certainly litigate policies that run counter to it that give rise to human rights violations that are protected under international instruments.
Thanks a lot, Rosemary, for this comment. Jens, would you like to comment briefly on this, how we can start addressing this containment? And as we see, containment is often related to crisis, and at least how a crisis is framed in the EU.
Thank you, Roberto, and thank you to the ECRI representative for this very pertinent question. As I just tried to write in a written answer, it is true that there is really a change for civil society policymakers to try to influence the EU Pact discussions and the legislative procedures in order to enhance compatibility with the Global Compact. As Nick already mentioned, there is little reference to the Global Compact, and the reference which is there is about the complementary pathways. I was insufficient in pointing to these what I termed as third country solutions, but it's clear that where the EU is trying to emphasize, or where the Commission is trying to emphasize cooperation with non-EU states, that is where I think there would be possibilities for civil society to push towards better compliance with the Global Compact. When it comes to the internal dimensions, the amendments of the Common European Asylum System, I would say that the arguments or the advocacy should rather be based on the fundamental rights principles, which are common to both the Global Compact and EU law already. Thank you.
Thanks a lot, Jens, for this additional comment. I would like to ask Audrey if she has any additional comment on this same issue.
Thank you. I think it would be presumptuous of me to speak about how activists in the European Union should be addressing this. I am sure that you deal with, as do civil society organizations in Canada, the real danger of co-optation when you are called upon, or you are, in quotes, consulted on matters that have already been decided and where the terrain of discourse is predetermined, and the risk that poses of then being described as having been consulted and having participated meaningfully when that isn't really the case. And I think that's often why litigation becomes the only pathway. It should always be a last resort, not a first resort, and I'm sure everybody knows that. But I'm distressed by the very small space within which meaningful consultation with refugees and advocacy groups can happen. But that's true of Canada, and it's my perception that's part of the problem in the EU, but I don't want to be too presumptuous. Thanks.
Thanks a lot, Audrey, for this further comment. I think, unfortunately, we are sorry that we are running, our time is about to expire. We have only a few minutes left. So I'm really sorry that we cannot address in further details other questions that are coming in, but we are of course always and willing and happy to follow up this in the context, in the follow-up of this session for many other questions you may have. There are only 2 minutes left, so I would like to close by thanking all the panelists for their valuable contribution. I would like to thank also all the participants for being with us and for actively contributing to the discussion with their question. A final thank also to the University of Essex for the team in Essex for their work in organizing this session, and also to my colleagues at CEPS, Miriam and Shun, for their support. I would like to wish you a good continuation of the day. Remind you that there are still other regional sessions today on Latin America, and also I would like to invite you to check the program on the website. So thanks again, and all the best.